All right, welcome back to the Daily Facts, and this is part two of the General Flynn court case. In part one, we went over his information here, and we also talked about the major players in the case. And I just wanted to play a little clip so that we know where it stands right now in terms of the General Flynn case. So let's take a listen to this video clip.
Why hasn't Judge Sullivan dismissed Flynn's case yet? Well, Elaine, let's be clear. The appeals court ordered him, and that's an important word, not direct. They ordered him to dismiss the case against the former National Security Advisor, Mike Flynn. And that's like the principal calling the teacher and saying, I know you don't like this action, but I'm directing you to take it. Judge Sullivan, you're correct, has not acted at this time. Lawyers I spoke to here in Washington today believe that he is considering his options or even toying with the appeals court decision. He has taken some limited action. He's told the government as well as the defense to file no more paperwork in this case. So effectively, everything is on hold, Elaine.
Okay, there you have it. Everything's on hold. So let's get into the case where we left off. So let's go ahead and get started. On the morning of January 24th, 2017, follow-up messages between Mr. Strzok and Ms. Page indicated that Bill brought it up again, this time in front of Director Comey, and that Deputy Director McCabe was frustrated and cut him off. In any event, that morning, Deputy Director McCabe called Mr. Flynn to arrange the interview. Deputy Director Andrew McCabe, Untitled Memorandum, January 24, 2017. He explained that recent media statements about his contacts with Kislyak merited a sit-down and expressed the FBI's desire to accomplish the interview quickly, quietly, and discreetly as possible. Deputy Director McCabe further advised that if Mr. Flynn wished to have anyone else at the meeting, including the White House counsel, the FBI would have to elevate the issue to DOJ. Mr. Flynn himself, a former director of the Defense Intelligence Agency, stated that he readily expected that the FBI already knew the contents of his conversations with the ambassador, stating, "You listen to everything they say." Mr. Flynn then agreed to meet with the interviewing agents in his office less than 2 hours later. Mr. Flynn was unguarded in the interview and clearly viewed the agents as allies. When interviewing Mr. Flynn, Mr. Strzok and the other agents didn't show him the transcripts of his calls. Let's just read this here. Pre-Stap's notes dated January 24th state, "What's our goal? Truth, admission, or to get him to lie so we can prosecute him or get him fired?" So Pre-Stap is asking that question. What do we want to do here? What's the end result that we want? What's our goal? Do we want the truth, or do we want to get him to lie so that we can prosecute him or get him fired? On the same paper, Pre-Stap wrote, "If we're seen as playing games, WH, White House, most likely, will be furious. Protect our institution by not playing games." Okay, FBI, a handwritten note, January 23rd, 24th of 2017. Another note stated, "We regularly show subjects evidence with the goal of getting them to admit their wrongdoing. I don't see how getting someone to admit their wrongdoing is going easy on him." Okay, so let's continue. Let's just go back here. When interviewing Mr. Flynn, Mr. Strzok and the other agent didn't show him the transcripts of his call, nor did the agents give at any point warnings that making false statements would be a crime. According to the FBI agent's recollections, when asked if Mr. Flynn recalled any conversation in which he encouraged Kislyak not to escalate the situation in its response to American sanctions, Mr. Flynn responded uncertainly, stating, "Not really. I don't remember. It wasn't, don't do anything." Mr. Flynn also stated that although it was possible, he did not recall any conversation in which the ambassador stated that Russia would moderate its response due to Mr. Flynn's request. He stated that he did not have a long conversation with Kislyak to don't do something. Meanwhile, when asked if he recalled asking countries to take certain actions on the United Nations vote on Israeli settlements, Mr. Flynn explained that the conversations were along the lines of where do you stand and what's your position, and that he did not believe his calls to the various countries would change anything. He also stated that his calls did not involve any requests for how to vote and answered no when asked if he discussed delaying or defeating the vote. Moreover, the FD 302 moreover indicates that Mr. Flynn denied that Kislyak described any Russian request to his response. FBI handwritten notes of Michael Flynn interview, January 24, 2017. After the interview, the FBI agents expressed uncertainty as to whether Mr. Flynn had lied. FBI agents reported to their leadership that Mr. Flynn exhibited a very sure demeanor and did not give any indicators of deception. Both of the agents had the impression at the time that Flynn was not lying or did not think he was lying. So there you go. The FBI agents that interviewed General Flynn did not believe he was lying, or they did not think he was lying. When Director Comey was asked, based on his evaluation of the case, do you believe that Mr. Flynn lied? Director Comey responded, I don't know. I think there is an argument to be made he lied. It is a close one. Now, it's my understanding, this is just me, my injection into this, that the FBI, they take copious notes, okay? They take notes, but they don't record anything. So I guess Comey is just reading what was read, but the agents, my point in this is that the agents were there. And oftentimes you can read a person's body language, and the FBI, they do that. I believe they're trained to do that. So let's continue. On November 30th, 2017, the Special Counsel's Office filed a criminal information against Mr. Flynn, charging him with a single count of making false statements in violation of 18 U.S.C. 1001 A2. Mr. Flynn pleaded guilty to that offense, but moved to withdraw that guilty plea on January 14, 2020, which is where it stands right now. Right, which is why Judge Sullivan, not Judge Sullivan, AG Barr has directed Judge Sullivan to release the case. There aren't even prosecutors prosecuting the case. So on January 29, 2020, Mr. Flynn also filed a motion to dismiss case for egregious government misconduct and in the interest of justice, and supplemented that motion on April 24th and 30th of 2020 based on additional disclosures. Both Mr. Flynn's motion to withdraw his guilty plea and motion to dismiss the case remain pending before the court. And we know that General Flynn was trying to get it released. It went before several judges, and they denied that. That was done. We're in September the 5th right now of 2020, and he lost that. So really it's where it stood before, with Judge Sullivan not releasing it and running around doing different things, but the case, and not doing the things that get General Flynn released from this. So Judge Sullivan is still holding tight, right? Federal Rule of Criminal Procedure permits the government, with leave of court, to dismiss an indictment, information, or complaint. It is also well established that the government may move to dismiss even after a complaint has turned into a conviction because of a guilty plea. And they give you examples here: United States versus Hector. When the government so moves, the role for courts addressing Rule 48 motions is narrow and circumscribed. The leave of court provision serves primarily to guard against the prospect that dismissal is part of a scheme of prosecutorial harassment of the defendant through repeated prosecutions. Let's just go back and take a look at this. On May 7, 2020, defense counsel confirmed with the prosecution team that upon the government filing this motion to dismiss, the defense would move to withdraw all pending defense motions without prejudice. Well, was the goal and the hope. A prospect not implicated by, as here, a motion to dismiss with prejudice. Okay. And they're citing Rinaldi 434 U.S. at 29 N15. So the discretion accorded the DOJ under Rule 48A recognizes that decisions to dismiss pending charges lie squarely within the ken of prosecutorial discretion and at the core of the executive's duty to see to the faithful execution of the laws. As the Supreme Court has explained, the factors relevant to carrying forward a prosecution, including the strength of the case, the prosecution's general deterrence value, the government's enforcement priorities, and the case's relationship to the government's overall enforcement plan, are particularly ill-suited to judicial review. That's Waite versus United States. For those reasons, a court should not deny the government's motion to dismiss based on a disagreement with the prosecution's exercise of charging authority, such as a view that the defendant should stand trial or that the more serious charges should be brought. Nor should a court second guess the government's conclusion that additional prosecution or punishment should not serve the public interest. We are unaware of any appellate decision that actually upholds a denial of a motion to dismiss a charge on grounds that dismissal would not serve the public interest. Based on an extensive review of this investigation, including newly discovered and disclosed information attached to the defendant's pleadings, the government has concluded that the continued prosecution of Mr. Flynn would not serve the interests of justice. And they outlined that above, the reasons why a case could be dismissed based on, this, what they pointed out up here. Let's see if we can locate that. Charging authority. Oh, I can't seem to locate it, but they outlined it up there. So they just don't see a reason to move forward and to prosecute. And we already know this, right? Yeah. Under the principles of federal prosecution, the government should not prosecute a defendant unless the attorney for the government believes that the admissible evidence is sufficient to obtain and sustain a guilty verdict by an unbiased trier of fact. A determination to prosecute represents a policy judgment that the fundamental interests of society require the application of federal criminal law to a particular set of circumstances. The particular circumstances of this case militate in favor of terminating the proceedings. Mr. Flynn pleaded guilty to making false statements that were not material to any investigation. And they have material in quotes. It's not material. Because of the government does not have a substantial federal interest in penalizing a defendant for a crime that is not satisfied occurred and that it does not believe it can prove beyond a reasonable doubt, the government now moves to dismiss the criminal information under Rule 48A. Proof of a false statement to federal investigators under Section 1001A2 requires more than a lie. Okay, so they're really explaining all of this. It also requires demonstrating that such a statement was material to the underlying investigation. Okay. Section 1001 prohibits knowingly and willingly making any materially false, fictitious, or fraudulent statement or representation in a matter within the jurisdiction of the executive branch of the government of the United States. As is well established, materiality does not equate to mere relevance. Rather, to be material means to have probative weight. That is, to be reasonably likely to influence the tribunal in making a determination required to be made. The materiality threshold thus ensures that misstatements to investigators are criminalized only when linked to particular subject investigation. False and birthplace statements in an immigration application were not material as they were not relevant to his qualifications for citizenship. That's just an example. Kunji versus United States. And it prevents law enforcement from fishing for falsehoods merely to manufacture, jurisdiction over any statement, true or false, uttered by a private citizen or public official. You know, this is pretty big. And this is a case, you know how we're seeing Kunji versus United States and different cases throughout here. It's going to be the United States versus General Flynn, because this is just, in my opinion, it's unprecedented. I mean, I've never heard of anything like this. And so this is going to be referenced going forward, I'm sure. In the case of Mr. Flynn, the evidence shows his statements were not material to any viable counterintelligence investigation, or any investigation for that matter, initiated by the FBI. Indeed, the FBI itself had recognized that it lacked sufficient basis to sustain its initial counterintelligence investigation by seeking to close that very investigation without an interview of Mr. Flynn. Having repeatedly found no derogatory information of Mr. Flynn, the FBI's draft closing communication made clear that the FBI had found no basis to predicate further investigative efforts into whether Mr. Flynn was being directed and controlled by a foreign power, Russia, in a manner that threatened U.S. national security or violated FARA or its related statutes. With its counterintelligence investigation no longer justifiably predicated, the communications between Mr. Flynn and Mr. Kislyak, the FBI's sole basis for resurrecting the investigation on January 4, 2017, did not warrant either continuing that existing counterintelligence investigation or opening a new criminal investigation. So they opened it, the FBI opened the investigation just based on the communications between General Flynn and Kislyak. That's the purpose of all of this. The calls were entirely appropriate on their face. Mr. Flynn has never disputed that the calls were made. Indeed, even if he had disputed it, it wouldn't matter because, you know, the NSA and other agencies, they have a record of this. And General Flynn has been in the government long enough to know that. He worked in the Obama administration. He's fully aware of that. Right? So he's not going to, you know, they're not going to be disputed. Indeed, Mr. Flynn, as the former director of Defense Intelligence Agency, would have readily expected that the FBI had known of the calls and told FBI Director McCabe as much. Right. Exactly. Mr. Flynn, as the incumbent national security advisor and senior member of the transition team, was reaching out to Russian ambassador in that capacity. In the words of one senior DOJ official, it seemed logical that there may be some communications between an incoming administration and their foreign partners. Such calls are not uncommon when incumbent public officials preparing for their oncoming duties seek to begin and build relationships with soon-to-be counterparts. We'll leave it there until part 3. But it's true. I mean, it wasn't as if he was President Trump hadn't won and had not, you know, given this role to General Flynn. He was now the in that role, right? He was doing what he was supposed to be doing in his particular role. So it's conceivable that he would be having these conversations and building relationships. I mean, it's not rocket science. So we're going to end it here. And thank you for stopping by the Daily Facts. I hope you enjoyed. Do like, share, subscribe. And until next time, bye.